In our post-Dobbs moment, we were immediately confronted with the ramifications of 50 years of rhetoric as well as court decisions in the post Roe and then Casey framework. And to get us started, Hadley, what did you see as the limitation of this federalism focus that the pro life legal strategy was largely centered on?
Well, let me just offer this overview that for 50 years, we had buses bringing people in from all parts of the country for the anniversary of Roe versus Wade in the worst weather that Washington ever serves up in the middle of January. And these people were there because they were animated by what they saw as a scheme that had about 1 million unborn babies being dismembered or poisoned every year. But that was not the wrong of Roe versus Wade as seen by conservative jurisprudence. Their concern was that there was no such thing as a right to abortion mentioned in the text of the Constitution. Therefore, a federal judge did not have the ground to proclaim any such right springing from the Constitution itself. And so it was a matter of returning the issue to the political arena. As Jerry pointed out, we thought it was people were brought there by concern for babies being killed, but apparently the mistake was a mistake in the separation of powers. That the judges, as friends of the Wall Street Journal say, the judges had simply wandered into the wrong lane. 50 years ago in Roe, the lawyers from Texas offered an elegant brief drawing on the most updated findings of embryology for the sake of putting this point before the court that nascent life in the womb has not been anything other than a human life from its very first moments. But the dissenters never took up any of that substantive argument or the moral reasoning which was woven into it, and neither have the conservative judges who brought forth Dobbs. So the curious part is that we overthrow Roe versus Wade, but the court says nothing explicitly to confirm the human standing of the child in the womb. Of course, they've done that. Well, Jerry and I both think it's all to be found there in Justice Alito's opinion, but they don't. But he didn't draw. Alito did not draw explicitly what came out of his argument. He tried to show that there's no principal ground for regarding that unborn child in the womb as anything less than human, but he didn't draw the conclusion. And so the court does not establish that we're dealing with that nascent life is a human life. If it had done that, then the 14th Amendment would have kicked in. Congress would have a clear ground for legislating, and federal judges intervening also when the blue states were withdrawing the protection of the law from a whole class of human beings. And the cases on chemical abortions would have been altered also, because then the question would not have been simply, is misoprostol safe for the woman who's ingesting it? Because there'd be a second person in picture now, that being that it was the very object of the drug to extinguish. So what we have here is the court not taking time to put another ethic in place, to keep pointing out to people the grounds on which we could justify restrictions on the taking that innocent life. And we thought so it throws it back into the political arena to a political class that has never been comfortable talking about it. And if Sam Alito was not ready to draw out the implications that flew from his own argument, we just couldn't count on the Trumps and others to do that kind of work. So we find ourselves in a situation where, you know, as I put it before, um, abortions will not be carried out in massive numbers in the blue states, and conservative jurisprudence will say, well, that's regrettable, but overturning Roe is all we ever promised to do. And so we now have, though, a situation in which we don't have a political leadership that's been sort of get practice in drawing out the implications that unborn child is a human being. And so we don't have the ground laid for an advance in the pro-life movement. So it's like what's your Woody Allen line? I'm sorry, I can't leave you with something positive. Would you accept two negatives? We have this. Now Jerry, I think makes a powerful argument. I'll turn it back to Jerry that that the Alito opinion really just establishes the ground for which you could argue that the ground on which to claim that the laws of the blue states are just untenable.
Well, I'll tell you, I have been myself at several, maybe many, January marches in DC. And of all the placards and speeches, placards I've seen and speeches I've heard, I think 90% of them have been about saving unborn children, not about righting a wrong about constitutionally allocated jurisdiction. And maybe there were 10% of the speeches and placards mentioned the Constitution specifically, but every one of them, as I remember it at least, mentioned the 14th Amendment and saying in some way, shape, or form that unborn people are people too, and they are entitled to the equal protection of the law. And all the marches I've been to, I have yet to see a placard or hear a mention of the 10th Amendment, which is pretty much what conservative jurisprudence boils down the question presented in Roe to when it comes to the Constitution. So that's one way in which the federalism resolution, so to speak, of the Dobbs case is really inapt, ill suited to the whole movement that produced that decision. I mean, not to put too fine a point on it, and I don't rely upon any information or data that's not available to you or me or anybody watching the podcast. But it's easy to see that Trump appointed justices made the difference in Dobbs. And I think it's pretty clear there's a direct line between the pro life movement, support of Trump, support of the kinds of people Trump said he would appoint to the court, and the Dobbs result. So the pro life movement, I guess I'm saying, produced Dobbs, but it's not what they always wanted. Now, a second way in which the federalism or 10th Amendment view of Roe and Dobbs is mistaken is that I maintain, Hadley referred to something I'd written at First Things about the Dobbs case. And no matter what the Dobbs justices say, and they do say as much as they remain scrupulously neutral about the status of the unborn occupant of the womb. And they do say that it's up to the people and their elected representatives to have, as they choose, pro life, that is, abortion restrictive laws or abortion permissive laws. But I would argue to this minute, I argued in the pages of First Things, that nonetheless, the justices don't get to be the masters of the logic of their own reasoning. They can offer commentary about what they've done, but that doesn't preclude us from examining what they've done. And I maintain that the opinion in Dobbs depends necessarily upon not a neutral view of the occupant of the womb, but that the opinion simply fails as a matter of reasoning, stave on the view that the court recognizes the unborn child, recognizes that abortion kills a living, whole human individual, albeit one in utero. And a third way in which the 10th Amendment take on Roe and Dobbs has proven to be a failure is just as we came to the crescendo point of the pro-life movement in, well, 3 years ago in 2022, and leading up to it in the 3 years since, we've discovered that it's actually practically impossible to return the issues to the state. Now, when abortion was a brick and mortar business conducted by medical professionals, not in the open view of people passing by on the street, but in facilities that could be easily identified and regulated by the state, when it was a matter of surgery centers and abortion mills, a state, let's call them red states, could effectively ban abortion if it was so minded to do. But with 60 and upward percent of abortions now being chemical or pharmaceutical, but a matter of telemedicine followed by a FedEx delivery or even a USPS delivery of abortion pills, we've discovered that red states are unable to prevent abortions in their jurisdictions. And I think my judgment is that red states like Indiana, where I live, that have effectively banned abortion, are almost defenseless against an invasion of abortion pills from, let's call them, blue states. And that without federal help through enforcement of the Comstock Act or some other federal action, I don't think that red states who have received back the authority to regulate and restrict and even to forbid abortion because of Dobbs, they discovered it's a Pyrrhic victory in the most straightforward sense of Pyrrhic. They're unable to do what it is the Dobbs case gave them the authority to do, the authority which Roe took away 49 years before that.
Could I ask you though, Jerry? Are you offering unqualified praise for the Alito opinion because Justice Alito, to command a 5 justice majority, had to do what he had to do? Or are you offering qualified praise because the kind of opinion that you would hope a lower court judge would do would require a Herculean lift to do what you're asking that lower court judge to do?
Well, I would like to steer clear of taking on board defense of the term unqualified, since I can always quibble. But I do think that there's a lot more of a pro life, I mean, genuinely pro life victory in Dobbs than even to this minute we, even pro lifers, tend to recognize. I don't myself fault Justice Alito insofar as from reading the oral argument in the case and certainly from reading his concurrence in the case, it would seem that it's a very plausible hypothesis that the price of bringing Brett Kavanaugh on board to get a fifth vote was, maybe among other things, the rhetoric that I referred to earlier of a kind of gross moral neutrality. That is Kavanaugh's position. And I do think it was essential that there be an opinion of the court in that case. And if I were the author of that opinion, and that was the price I had to pay to get that fifth vote, I would pay it. But as I say, that just makes it all the more important that not just law professors like myself, commentators like the three of us, everybody who can do so should take it upon themselves to judge what there is in the Dobbs opinion. And I do think that it's a much more of a pro life opinion than we tend to think. In fact, I think it's a remarkable achievement that Justice Alito got that opinion subscribed to by 5 members of the court. So I think that while the court did not hold that the unborn are constitutional persons, and there's a case to be made that it wasn't the right case to do that, nonetheless, I do think that the opinion, Dobbs' opinion, all but establishes the following proposition, which on the ground could give you equal money, equal value for the constitutional personhood proposition. But I do think the Dobbs case establishes that in an abortion permissive state, one withstanding could and should challenge the abortion permissions as lacking a rational basis. Not that the attractiveness of abortion lacks a rational basis. I can appreciate the attraction of abortion, but any abortion permissive law depends upon the prior question, resolving the prior question of whether the unborn count as persons. Even Harry Blackmun got that right in Roe, and he didn't get many other things right in Roe. But Harry Blackmun said explicitly that the question of constitutional personhood came first, and if the unborn count as 14th Amendment persons, and this is a close paraphrase of what Blackman wrote, the appellant's case, of course, collapses because then abortion would be constitutionally impossible due to the personhood of the unborn. Now, again, Dobbs did not hold that the unborn are persons, but it undermined and corroded all the foundations behind the view, the conviction, that the unborn are not persons. And there's no, I think after Dobbs, you can make a sound argument, a compelling argument in court, that there's no rational basis for holding that the unborn count less than you or me or Hadley or anyone else. And for that reason, or in that way, I think abortion permissive laws are unconstitutional for lacking a rational basis. That one of the essential premises, namely that the unborn don't count, has no rational basis. Now, it has a basis, but it's rooted in the convenience, the desires, the wants of other people. But we know that's not a rational basis, thank God, for thinking anything about someone's humanity, their human dignity, or their status as human persons. For if some other person's desires and wants could determine your status or my status as a person, well, then we would all be in trouble.
I think that, Jerry, I'm trying to recall the term that comes into play with the argument you're offering. I mean, except like what comes closest, notion of extruded. That is, once Pythagoras gets the theorem out, it's extruded. It's out there. He no longer has possession of it. And I think so. The the beauty of your argument is that, well, Sam Alito was constrained from drawing the conclusion that came from his argument. He had Kavanaugh saying, "Isn't it interesting that so many pro-life people think that believe that the unborn that the fetus is human, believe it, as though embryology had nothing to tell us very precisely about the beginning of their life over the years." He couldn't, so he was constrained from drawing explicitly that conclusion. But I think your point is it's there, though. The argument is there. It is there. And it needn't be confined to the kind of conclusion that Alito felt himself constrained from reaching. So the
And I
question
think
is,
that's quite right. And Alito actually wrote, and this is the conclusion to an argument that he mounted, which is dialectical insofar as it's an argument mounted to rebut the positions of the concurrence by Chief Justice Roberts and the dissenters. Those positions in substance were amounted to saying there's a middle ground between reversing Roe and abortion on demand. But the Alito opinion shows that there's no middle ground, no stable and defensible middle ground. I think the best way I could express what Alito establishes is that there's no non-arbitrary distinction between even the embryo and perhaps in a certain way, even more the fetus, but there's no non-arbitrary distinction between the unborn child and the born child. There is a distinction, but none of them can carry the weight. One is inside the womb and one is not, for example. But no one thinks, and this is really the structure and tenor of Alito's argument, well, nobody really thinks that someone could be a person, for example, if they're in a big city university hospital and can be saved at 25 or 27 weeks gestation, that would make you a person in New York City. But in Ithaca, New York, where the hospital is not quite that, and a baby born at 26 or 27 weeks would die, you wouldn't want to think that, oh, well, that baby wasn't a person because they happen to be in Ithaca, not New York City. So Alito's mode of argument is that although there are some differences between the born and the unborn child, none of them amounts to the kind of distinction that can bear the weight of judging one to be a person, or to put it even differently, judging one to be a human being with a right not to be killed, and judging the other to be something else with no right against lethal violence.
So there it is. Though I think of Sam Goldman's old line that a verbal contract isn't worth the paper it's printed on. Or you might say say that yeah, an tacit agreement is not worth the paper it's printed on. And the difficulty for us is it's still implicit. It's still implicit. And the difficulty is that can we find the federal judges who are willing to take that next step, which I think is already contained. I think Jerry has it absolutely right. A judge, somebody could come in as a guardian ad litem in one of the blue states to protect a child who's threatened, and a federal judge would have to. And yet, what we know about conservative judges is that they're conservative, they're cautious, they're reluctant to take a move of that kind. And after all, look, they had the mifepristone case coming soon after, and Alito was saying, "Well, isn't it illegal right now to send materials of this kind through the mails and interstate commerce?" The Comstock Act was there. He was trying to say, well, he didn't take the occasion to say, there is a second person here. Taking my opinion, you can't show there isn't a second person here. We should take. So they're reluctant yet to make that move. They're reluctant to make, which is what made me think it's really is Alito himself would have to give some signal here about a willingness to do it, which I thought perhaps in the Skrmetti case he could have said, take the Skrmetti case and say, quite apart from what the legislature says, then I invoke Professor Bradley to say sex is immutable, that these transgendered surgeries were predicated on the falsehood. You can't convert a male to female or female to male. I thought maybe if he could have said something like that, given an example. But let's take it back I'm take it back to your point earlier, Jerry, about the fact that the states, we returned it to the states. Trump wanted to work with the fiction that the court returned it only to the states. The court returned the matter to the political arena, not simply to the states. But the problem here is that unless you're clear that there's something wrong with abortion, then we have the matter of sending these materials in interstate commerce, and no state itself can put up the barrier. So as you say, the Congress would have to come in and do something comparable to what they did in the days of prohibition. If a state wanted to keep a dry state of faith, they'd have to bar spirits from being imported into the states. That would take the intervention of Congress to support the states that wanted to do that. So it's a matter of talking about the future of the pro-life movement and the pro-life Congress. The Congress would have to come forth with an attempt simply to protect it. But right now, we probably couldn't get 60 votes in the Senate to bring that kind of a bill to the floor, right? So we're paralyzed now. And in that moment, so what else could be done, Jerry? The chemical abortions, could they go back to saying, well, we should restore at least the sense that there should be consulting of real doctors in person. These are dangerous things to be taken on your own. Something like that.
Well, one thing is, it wouldn't take an act of Congress of any sort to revivify the Comstock Act. Don't hold your breath waiting for it to happen, but you certainly could take some comfort from the view of the president that he's in a position as the head of the executive branch to order the Justice Department to do pretty much whatever it occurs to him he wants them to do. So we certainly have a president, a muscular and broad-shouldered president, who, when he judges that a policy ought to be pursued, and when that policy can be pursued through criminal prosecution, he doesn't hesitate to do so. So the president does have that authority simply to order the 94 U.S. attorneys or a Maine justice or all of them to enforce the Comstock Act. Now, what would require legislation, and I haven't seen a draft of such a legislation, and I couldn't at this moment give you even a rough draft of it. But it seems to me there could well be a new federal crime which would be enforceable without respect to state borders. But the federal crime would be quite precisely sending, knowingly sending uh, material to a, let's call them red state, for the sake of promoting an abortion in a state where it is illegal to have an abortion. Now, I can't think of any reason why there wouldn't be federal jurisdiction there, whether under the postal power or the commerce power. I don't think that's the problem. And of course, if it's a federal crime, then it doesn't matter whether the governor of New York is willing to extradite a doctor in White Plains who is sending abortion pills all over the country. Uh, there is such a doctor who's been indicted in Louisiana, if I remember correctly, and that's just fine as far as I'm concerned. But the governor of New York has declared that she will never extradite any person indicted for that crime. And this, in our legal system, and maybe fortunately, I'm not sure, maybe unfortunately, there's practically nothing anybody can do to make a governor extradite someone that the governor doesn't want to extradite. So you would need, you might say, prosecutorial authority with nationwide jurisdiction. Now, that is the United States. So I can't myself think right now of any drafting obstacle or other impediment to writing a statute that would do that job. Again, tailored rather specifically, to mailing abortion pills, knowingly do so with the intent to assist a woman in a red state to procure an abortion that the person sending the pills knows is illegal in that state. Now, that gives you plenty of what the criminal lawyers call mens rea. There's plenty of intent there, plenty of knowledge to really assist in the conduct or the performance of something that's illegal in Indiana, for example. Now, I know that in Indiana and elsewhere, as far as I know, a woman who self aborts with pills is herself not guilty of a crime. But a person doesn't have to be, you can be guilty of have accomplice liability to a crime, even if the apparent principal is for some reason immune from prosecution. So, for example, you could be an adult indicted as a co-conspirator, for example, with the other for drug distribution or some kind of violent activity, where the other people are minors who cannot be prosecuted as adults. They're immune to criminal responsibility. They could be hauled before a juvenile judge, but there they would be subject to juvenile adjudication, but they're not criminals.
Well, the pro-life movement has always sort of looked as the woman as the one under pressure here, another victim, as opposed to the abortionist who knows precisely what he's doing and makes the killing of the child his office work. But let's just put this thing in a scale for a moment. That what we'd have Trump's vice presidential candidate, Vance, already waived any objection to the chemical abortions. So once they've done that, um, if Trump is not contesting that, it's a difficult step for him to say that now I'm going to deny the freedom to send these things through the mails. It's a harder pull for him then. It's going to take a real
Well,
leap
it
and
could,
do
I mean, it
except
will up
wait
to a point.
okay, but my point is what we're offering here is a different kind of appeal he could make. He's saying I'm not going to contest this stuff. I'll just make an appeal that the limited reach here was to consider this as simply a matter returned to the states. And I want you to join me in simply allowing those pro-life states to have those laws. And so I'm asked simply as a lesser measure here to see so we could just make this kind of a concession as a kind of compromise within this political compromise here.
No, that's quite right. I mean, and really, the out of state abortion pill provider should be likened to the doctor who performs surgical abortions and in some places still do. So, really, the pill provider is an abortionist. And the surgical abortionist could always be prosecuted in a red state, even though the woman whose body he or she, the abortionist, operates on, that woman is immune from criminal responsibility. And I think you're quite right that Trump would have, or Vance or whomever is the responsible actor or the spokesperson, would have, I think, very plausible cover if one feels it's needed. If in the, um, you might say, the spirit of Dobbs and consistent with the Trump's rhetoric during the campaign, that Dobbs returns the matter to the states, a law of roughly the sort I'm describing and contemplating could be packaged as simply doing what the president promised he would do, which is to return the matter to the states, which, as I mentioned at the get-go, it's been an illusory or phantom return to the states because of the ease with which the abortion pill can be sent across state lines. So I know President Trump has made it his theme and never hesitates to say that his administration is about promises kept. Well, there's a step he could take and probably and should take to keep his promise about where abortion authority belongs in our constitutional system, because the blue states are robbing the red states precisely of that authority.
Right. But actually, there's another angle here that is useful when we consider the future of the pro-life movement. Our old Born Alive Infants Protection Act, where we passed that initially, we had no provisions for enforcing the act, no criminal penalties. But then we went back to that in 2015 after we had the revelations from Kermit Gosnell's abattoir in Philadelphia, where he was really snipping the necks of babies who survived the abortion. And then we got together a crew to revisit that statute to add civil and criminal penalties. And by this point, there was high cohesion among the Democrats. They supported the bill initially because they were too embarrassed to oppose it back in 2002. But now they're utterly cohesive in resisting the move to penalize the man who kills a child born alive. They were voted virtually unanimously, except for one or two pro-lifers still hanging out, which is to say, for the Democrats, the right to abortion really did not find its terminus even when the child was born alive. Now, the pro-life movement was pushing this thing, but then when Trump took the line in the campaign that this is being returned solely to the states, the sense was that there's no point of having him raise the Born Alive Act because it looks like national legislation on this matter, and we thought he's going to avoid national legislation. Except it turns out that they're willing to bring it to the floor again. They're making sounds of bringing it to the floor. Thune is willing to bring it to the floor again. Our friend from Oklahoma, Langford, I think is willing to do it. Now, is that serious? Once again, they're not. It's going to be hard to get 60 votes to get that thing to the floor, as we found 3 times over the last 10 years now. But if that were done, if they could really put that one through, Jerry, my goodness, there would be a ground in which a guy might like to come in to challenge those laws now in the blue states that do allow the child to be killed even if it survives the abortion.
So
Correct,
to be clear, the Senate did vote in January by a 52-45 margin to advance the Born Alive bill, but of course that fell short of the 60 vote threshold. So it's not just speculative. Indeed, this administration did not object to Senate leadership bringing the Born Alive Act as it has done over the last decade to the floor and having a vote on it.
Sure. Look, if Donald Trump was willing to tear at Hillary Clinton, say, Hillary, you saying you could tear this child out of the womb of the mother and kill it at that point? That's appalling. I'm not okay with that. Well, the same Donald Trump could say, "What do you mean? You're telling me the baby is alive and survives the abortion? Donald Trump could encompass that just quite as readily. Could be his his understanding here to do it. And if he did it, who knows? Maybe that could be a breakthrough. And the fact that they're still willing to put it forth in the Senate is a sign. So they see the curious thing is, Jerry, is that there are pro-lifers in this administration. There are pro-lifers in the Department of Health and Human Services. We don't have Roger Severino there anymore, but there are people there who are willing to take a pro-life perspective, and any the levers the levers of the federal government are so. I mean, you pointed out this years ago that abortion has been a business of the federal government for a long time. In many instances, there's so many places where the federal levers really become telling.
Right.
And so, I would like to, for the benefit of our listeners, hook back into what we consider to be such an important, element of this natural law moment that we're living through. That indeed, the natural law counsels prudence for determining when the fullest impact of our principles should be instantiated in our policy. And I can think of few issues better than abortion, in which indeed the fullest instantiation of the principle of equality under the law, extending to all persons, preborn and those who are born, would fall within the realm of a statesman to make the kind of determinations where the law needs to act as a teacher, even if it can't vindicate every one of its victims. And I think of Lincoln, and Hadley, I learned this from you. I think of Lincoln counseling his attorney general to prosecute not the slave owners, but rather the slave traders during the Civil War, because that was something that was well within his power to determine on how to prioritize um, those who were in contravention of the laws that the Lincoln administration went about enacting. But I could see this administration, even if not fully embracing a pro-life program, picking and choosing its priorities, and those priorities could go towards restoring a culture of life, even if only modestly. What do you think, Hadley and Jerry? What do you think about that?
Well, any one of these levers will I was surprised I saw that the this fine blue book by Steve Calabrese and Gary Lawson over Ed Meese in these years. And when it came to abortion, they said, well, the Constitution uh, made no provision on when human life began. Of course, who at the time thought they had to do anything like that? There's no mystery about this. Let's invoke James Wilson here, right? If we have natural rights, when do they begin? And his answer was, they begin as soon as we begin to be, which is why, as he said, the common law casts its protection over human life from its first stirrings in the womb. And I can't see why people are so befuddled by that question. The regime begins with the Declaration of Independence, the claim to protect people from the unjustified taking of their lives. It's designed to protect the natural rights of human beings, not to deprive them of their life, their liberty, without justification. They weren't in doubt as to what a human being was or when it began. I recalled, I did that book of my natural rights and right to choose. I recalled uh, the shooting at a uh, Planned Parenthood in Brookline, and then someone was killed. And then a couple nights later, there was a woman there in a candlelight vigil with her baby daughter. She's there to protect her baby daughter's reproductive rights. Right? It's including that right to kill that same baby daughter even after she emerged. So remember, we raised the question: if that daughter had those reproductive, when did they begin? Were species of natural rights? Did she have them when she was in the womb? Well, if that's the case, the mother couldn't have been warranted in depriving her of her reproductive rights by sweeping away in one stroke the bearer of those rights. So it must be that the mother in the grand Nietzschean gesture said, I now confer upon you the right to live, because nothing about you is inconsistent with my interests. In other words, the right to abortion is a right conferred by the powerful as it suits the interests of the powerful to continue it. I just think there's so many places in which that can become engaged when we simply remind people of what we're talking about here. But as we've seen, the IVF, Jerry and I have been very much involved with that. People say, well, the the well, we want to bring forth life and so on, but at the same time, you're not noticing that those frozen embryos are human lives. That people, once again, people have to be tutored again. Just over the years, what are we teaching people? So let's bar abortions later in life, or bar later in pregnancy, or bar abortions when the heartbeat can be heard. Of course, these are not markers in a human life. These are simply markers in development of a human life already in being, powering and integrating its own growth. So you think, Garrett, going forward, what have we been teaching people as we've offered these schemes for legislating on abortion, and sort of finding these are convenient markers. Our friends at the Wall Street Journal have all abortions late in the pregnancy, as though somehow that made a difference as to whether we're dealing with a human being. So people, there's a lot to be shaken from. People to start reflecting again in a serious way about why these formulas we've been using just don't touch the problem. So you realize there's a lot that we have to learn again, and that provides us with kind of some steady work.
Now, on IVF, Jerry, the concern that so many of us have with this emerging technology is that it's operating outside of a framework of what we would consider to be natural law. It need not be that way, and yet this is frequently described as the Wild West, where if we don't do it, some other country will, and the United States will fall behind in scientific progress and technology. Give us a sense for the challenge, in particular for the future of the pro-life movement, to make the case for the standing of the unborn and the quality of all of us, even in our earliest stages, in light of how rapid the technological advancements are occurring with IVF.
Well, there are two things, at least of a strictly legal quality, that I'd offer in a partial response. One is that I think it's fair to describe not just the international scene concerning IVF as a Wild West, but I think the scene within the United States has been and still is a Wild West, meaning IVF is scandalously underregulated industry as a whole. And I suppose I should myself offer a mea culpa, because myself and so many others in the pro-life movement over the last 30, 40 years, while leaning into the work, pushing back against Roe, I think probably all of us to some extent neglected to focus upon this emerging organized form, institutionalized form of abortion or child neglect, namely IVF. I can say for myself, having been in the pro-life movement for these decades, that going back to the 80s, 90s, even the beginning of this century, we paid scarcely little attention to it. Many of us were involved in the composition and defense of the Unborn Victims of Violence Act, the federal law against feticide, basically. And it describes the child in utero as a member of the species Homo sapien at any stage of its development. So that means an embryo within the womb is a child who happens to be in utero. And destroying that child in utero counts the same for criminal liability and punishment as if you kill the mother. But even when we were working on that statute, I don't think we turned our minds to children at the same stage of development who happened not to be in utero, namely embryos frozen cryogenically across the country in different facilities. We just didn't give it the thought I think that we should have. And the second thing about the law is that President Trump, shortly after he was inaugurated, well, he issued executive orders all for the better on abortion. He reinstated the Mexico City policy, announced his intention to enforce the Hyde Amendment. So he has shown himself, and his administration has shown itself to be, I think, staunchly pro-life in certain ways, especially with the matter of funding abortions. But he also issued an executive order which was, let's just say, welcoming and even ecstatic about IVF. And the president, in the executive order, I think it was January 25th, or very close to that, said that he wanted to make IVF much more affordable for everyone. And he directed the relevant cabinet secretaries to come up with regulations within 90 days to affect the objectives of this executive order. Now, we're well past the 90 days, and there's no sign of those regulations. It raises questions about what's going on and what likely is eventually to emerge. But we're well past 90 days, and as far as I know, there's nothing in the hopper of anything like a public nature. I suspect myself that eventually something will come of the executive order, but it won't be proposed regulations. It'll be sounding in further development and indications about where the administration might go. But I don't think we're going to see regulations, proposed regulations, anytime soon. So I think that the ground is still fertile enough on IVF for pro-life people, as far as federal policy is concerned, to weigh in and to capitalize on the obvious antipathy of the administration for funding abortion. I don't expect to make a convert of President Trump on this question, but there may be a way to take some wind out of the sails of that executive order by doing all that we can to liken funding IVF to funding abortion. I mean, the Alabama decision about IVF, which seemed to get everybody very, very excited and revealed a very widespread consensus in favor of the availability of IVF. But nonetheless, the Alabama decision pretty much just drew the logical conclusion that even Sam Alito would draw, according to his reasoning in Dobbs. If the embryo inside a woman is, as federal law stipulates, a child, then an embryo that happens to be unfortunately outside of someone's embryo must be a child. There can't be, and this is the Alito-esque aspect of my reasoning, we really can't believe that if the child in a womb, if the embryo in a womb is a child with the same right not to be killed as its mother has, that the embryo located, accidentally speaking, accidentally you might say, elsewhere is what? A non-person, not a child, an entity that's pre-human or pseudo-human. Now, nobody should think that. And I dare say, and this is the comparison to Dobbs, if you take the Dobbs opinion to heart, nobody could think that. Now, again, I don't say that this logic or the obvious quality of the parallel between the embryo who is a child while within a woman, how it could become a derelict creature of some subhuman status when it's outside the womb, that's confounds reason, and certainly the position that they are different and that one can be frozen in perpetuity or simply destroyed. But if you destroy the child in utero, it's murder. Now, defending that on a rational basis, I think, would be pretty difficult indeed. So anyway, that's the structure of the argument to be made about prospective federal funding of IVF. Now, we're not talking about realistically a federal ban on IVF, and for that matter, maybe unrealistic to think any state, red, purple, or blue, will ban IVF. And well, so much the worse for all of us. But nonetheless, there is, I think, some prospect of diminishing or cutting off federal funding of IVF, notwithstanding the executive order. So I would encourage people who have the gifts and the time and the skills to deploy them in this field.
That's very good. Jerry, let me take just, there's one thread there that leads back to a point that Garrett was making. And one is, I, I wouldn't reproach you or any of us for neglecting to make these arguments over IVF, that we're dealing, after all, with real human beings and dealing with a frozen embryo. We knew this, but, to take that old line from Edmund Burke, refined policy is ever the parent of confusion. We just didn't think we had much of a chance of explaining this to most people who somehow thought that it made a difference as they were earlier or later in abortion, that the child was more human later, as it looked more closer to human beings, but people we knew, that if people were having difficulty with that one, it was even harder for them to grasp the notion that that cluster of cells now frozen is a real person. All of which gets us back to what we're after here. That Garrett raised the matter of Lincoln. Remember, Lincoln was saying, we need some place to talk about. Here's slavery. We can't talk about it in the churches. It's too explosive. We can't talk it about in politics. It's something that's at the center of the issue, and we have no place to talk about it. But what he meant was, part of that is that the real function of statesmen is how to teach people how to talk about these things. Why Lincoln would say, well, that black woman may not be my social equal, but in her right to eat the bread she's earned through the labor of her own hands, she is my equal, the equal of any other man. Lincoln found a way of talking about these things in a way that ordinary people could understand, and that his lines made their way into those letters of the Civil War soldiers. And the problem is, it just down to that. We need to have people who could just state the truth of this matter. That, as Sam Alito said, if you could protect that life in the womb after the point of viability, why can't you protect it earlier? It is, after all, the same entity. There's nothing mysterious here. It's just a matter of political people, just showing the wit to sort of get these things across in a way as disarming as Lincoln had, to just explain I remember years ago at Princeton, when I was visiting, the president Shirley Tillman, was giving a lecture, and at one moment she mentioned the pre-embryo, and I said, I just want to be clear. You're not saying, I take it, that what you call the pre-embryo is somehow a different entity from the one you call later the embryo, the fetus, and that one we'll come to know later as the anchor on the evening news. And she said, yeah, oh no, of course, you're absolutely right. You're absolutely right. And this is the point that Sam was trying to make there. We're talking about the same entity. It doesn't take much for a political man to say, look, we are talking about the same entity. If you understand that this is a human life, then yes, we learn it. It's not that the beating of the heart marks the beginning of human life. That life is already there and growing. And it's not mysterious. As James Wilson said, that first generation didn't find anything mysterious about this. We've just been an overlay of theories that people have talked themselves out of the things that we naturally know.
Well,
So
I think those theories I would call them rationalizations. When we began to have a reason, or whenever in our culture, as a culture, let's say in the 60s, starting in the 60s, developed a reason or took upon itself a desire to be free of the consequences of sexual intercourse, that is to say, what they call unwanted children. But when the people in that culture decided they wanted to do something and the unborn child became an impediment to doing that, they began to rationalize. And I think that's all it, even the most fine spun philosophical accounts of why people don't begin until sometime after conception. And I don't mean to impugn anybody's good faith as a scholar, but I think they amount to rationalizations for a position which is really not actually defensible as a matter of sound reasoning. I mean, what you're really saying, and really what you're saying, I think, Hadley, is that um, the burden should be on anyone who asserts that between, let's say, the time an infant becomes an infant, that is, right after being born, anyone who asserts that there's a substantial difference between that newborn and that same creature 10 minutes earlier, I think the burden is on that the person claiming there is a substantial difference. And if you want to say that, pick a different example during the course of a pregnancy. If someone says, well, you can't abort a post-viable fetus because that entity has the rights of persons, I'd say, well, fine. But what is it that justifies you in saying that a week earlier, that is just before viability, it is substantially different? And work yourself all the way back to conception. I do think it's fair, if I can imagine myself being in some way indifferent on the question of abortion, I think just trying to, if you understand what's being argued, that there's an entity that has an absolute or exceptionless right to life at t plus one, and anyone says, well, they don't have that right to life at t minus one. I think that's a position that needs to be explained and defended, rather than someone who maintains, no, t plus one and t minus one, they don't amount to a substantial difference. Or to take an example that I referred to earlier from Dobbs, someone says, no, a 27-year-old, a 27-week old fetus, let's call the baby, in New York City has a right not to be killed because it's viable. That same being in Ithaca, New York, has no right not to be killed. And then the person maintaining that would have to explain why the physical location of a living being amounts to a substantial difference in the dignity and the rights of that being. Now, that's an improbable position just on its face. And that's why I say it has to be argued for. And I do think that would be the position to take if one had no opinion about the morality of abortion.
Right, right. Of course, this was engaged when we did the Born Alive Act, because the challenge was we're gonna we never conceal this. We said we're gonna come back to say what was different about that same child 5 minutes earlier, 5 days earlier, 5 weeks earlier, 5 months earlier. What is that? What same? It's the same. It's the same entity, and that and there was a surprise that came here, that when we came out with that bill, the National Organization of Women and the pro-abortion groups opposed that bill to protect the child who survived. They opposed it right away, outright. And our own allies, like Henry Hyde, was saying, "Jesus, why? What's the value of coming forth with something as modest as this?" And the problem was the other side opposed it because they saw the principle that lay at the heart of the thing. And so the real irony here is that our adversaries understood the measure more clearly than our own allies did. But that's exactly what's engaged. To say, as you say, yeah, the burden should fall with you. If you think there's a difference, tell us what is the difference that as this entity losing the same claim it had to your tolerance and support when it was out of the womb that doesn't have now. It's a matter of shift. But in shifting that burden, it's what we're doing. We're trying to, as Lincoln would do, try to give people a different way of talking about something that should be so plain. It's just a matter of of discovering the natural way of talking about these things.
So this discussion is occurring in the backdrop of what I think is probably the strongest challenge to pro-lifers going forward, which is family formation is at generational lows, and while teen pregnancy, thankfully, is also down, a very significant reason for teen pregnancy being down is the lack of socialization of teens to even interact with one another. Um, a pro-life America may experience something like a renaissance from the ground up, but in the backdrop of this hyper atomization and this, I think, deeply, deeply troubling divorce between children from the institution of marriage, it's a tremendous uphill battle. Are there any points of optimism that either of you can point to that for a pro-lifer who's looking for signs of optimism are encouraging? Or is this one of those examples of Woody Allen's line about, I'm sorry I couldn't give you something positive, will you accept two negatives?
Well, actually, no one has written more eloquently than Jerry about this matter. That when you talk about it matters profoundly is whether you understand that sexual engagement is occurring within a framework in which you are committed to one another, giving yourself to one another, barring my freedom to quit this association as it suits my convenience. No, so you know, Jerry has been he's been the most eloquent in making this argument over the years. And so what? So Gary, what do we have to do to? Why is this disappearing? Right now, it's the religious who are having babies, and I see. Someone just told me the other day of a new interest expressed in the New York Times about a birth dearth. Maybe we have to encourage women to have more babies. But our friend Catherine Pekulik has done an interesting book on children with families with more children, and she said no, a public policy does not seem to be the real animator here. Giving people more benefits for having children, it may stage the affect the staging of this when they have children, but it doesn't really impart the motive to want to bring forth children. What what's your sense, Jerry? What this is going to, what this is going to need?
Well, I would recommend, by the way, to anyone viewing the podcast, taking a look at Catherine's book, Catherine Pekalik's book. It is repays the effort, repays the trouble to read it. And yeah, it's an excellent work and thought provoking in the best sense of the term, thought provoking, and very well done. Catherine is a great pro life figure and warrior. I was reminded during your setup of the question, Garrett, of a very recent column. I think it was in Public Discourse by our friend Ryan Anderson of Ethics and Public Policy, in which the money line of that, and Ryan had statistics to back it up, but the money line was the biggest cause of abortion in our country is non-marital sex. And although he doesn't footnote me, and he probably shouldn't, but I, for 20 years or more, have been giving talks, maybe 30 years, about abortion. And some of those talks would bump into the question, whether I'd raise it during my own remarks or respond to a question from the audience. But I've addressed in talks the matter of, well, how should we address or can we address the root causes of abortion? And even well meaning pro life people, their minds almost immediately go to things like child subsidies and tax breaks and better maternal health care and good things, I suppose. But that's where good people's minds go. And I impishly rejoin, if that's the context, or just volunteer. I said, well, I may be naive, but it seems to me the root cause of abortion is that too many people are having sex who have no interest in having children. So that's what we're up against. And even if teenagers are having less sex, I think the sex that they're not having would be no more interested in having children than it was in the old days. But there are some signs, maybe faint, but I think real, signs of revived social, political, and cultural interest in children living with and being raised by their married mother and father. I think there are detectable signs of that. I mean, there's always been evidence that that's the way to go. That juvenile delinquency, school achievement, social adjustment, you name it, is better for kids raised in intact families. But it's coming at it from, I guess, not only sideways, but from all the way around the corner. But the growing wariness and even opposition that is detectable among young people, especially young men, opposition to same sex marriage, I think is a reflection of a recovery of an appreciation for the mother and father married with children family. Now, there are other indications. Now, it's easy to say you wish for it as your own future, but do nothing to bring that future about. But the number of people, the percentage of younger people who say what they want out of life is precisely, well, maybe not what their parents had, but what their grandparents had. They want to marry one person, they want to have children, and they want to not get divorced. Uh, but I do think there's something real there. I mean, as I say, it's easy to say this is what my dream life, but do nothing to actually bring it about. And I understand that. But I think that there are any number of reasons why the culture is poised to rediscover, let's call it something, the virtues of the intact marital family. And I think that we should encourage any such sign, whether it's positive or negative, negative in the sense of being opposed to same sex marriage and opposed to anything else. And I think do what we can to revive that. I think that there's a place for a legal component of this, what I've so far called cultural effort. I think there's a place, not realistically speaking, for a move to overturn Obergefell. I don't think that's going to happen. But I think that a legal movement to limit the effects of Obergefell, to find in state law safe harbors for what I would call the natural family or the conjugal family, to take Obergefell, for example, at its word or on its own terms, where Justice Kennedy got almost nothing right in Obergefell. But he was, I think, aware, very consciously using consistently, I might even say religiously, the term civil marriage for the subject matter of that case. He always referred to it as civil marriage. And when you look to see what he meant by that, he clearly has in mind something created by the state for the sake of objectives of the state to structure the distribution of benefits. And unfortunately, in Kennedy's view, that the state creates civil marriage for the sake of affirming and recognizing and saying, you're fine to people who want to get married. But he was very careful, and I think understood himself to be very carefully avoiding contact with real marriage, natural marriage, the kind of marriage that thought he was in, I'm sure. So that I think that that's just one pathway through Obergefell, not reversing Obergefell, which again I don't think is going to happen, but a way to think about Obergefell as limited to a civil creation and status. And that if we begin to think boldly about no, not something the state created, but rather the state recognizing a natural truth and reality to the family and registering that in some fashion in state law, then at least you've got a distinction and a status in law or a place in the law specifically for the conjugal family. But I do think there are these signs, still, I think, faint for the most part, but are surely there and could be and should be developed with all deliberate speed.
But Jerry, there have been moves to start some gentle and subtle counters to Obergefell. We had just Garrett and I working a couple of years ago on trying to bring forth Roger Severino's old bill, the defense of monogamous marriage, as a place of DOMA, which would be an interesting part because if the court would sustain that bill, then it would sustain the notion, contrary to what they held in Obergefell and Windsor, that yes, the federal government may have a tenable role to play in legislating on marriage. If the court rejected it, it would be virtually installing polygamy. We had the possibility of doing that, and Paul Ryan's chief of staff told us, well, if you get a congressman to bring it forth, we'll ready to sponsor it, we'll bring it to the floor. We had two possibilities, two conservative Republicans from the Midwest. Both of them lost their primaries. That thing, but it's still, the idea is still there. But also, uh, there is another notion is that we could just move to not not allow people to be punished and withdrawal of federal funds or any penalties for people who simply hold to the notion of marriage, as was immemorially held, of the legal union of a man and woman. Now, Kennedy did not want to see the religious beaten up over these things. We can say, look, we're not challenging um, undoing same-sex marriage, but we're not. You shouldn't be beating up as part of the culture war on people who still hold to something that even Barack Obama would not deny until the last moment. He said, well, that could be an interesting move. Not, we won't be using the kind of laws barring um, discrimination on sexual orientation, the kind used to get the master baker, uh, in Colorado. But you just can't beat up on these people. And what's another way you say, it's not really a wrong. We're not going to consider it a wrong in the usual sense and beat up on people. But I want to take it back to again what the change has to be. There was um, I've heard the story from my oldest son in California. Is in a community of 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 Latin people with farm workers, and people are having children but they're not married. And I said, well, what is it that why would you, if you're having children, why would you not get married? What's that step that bars you? I mean, you're taking a step to saying, I am committed to this person. I'm willing to commit myself not to let go of her or the children simply as it suits my convenience. Thought it's some serious questions have to be put to people as to what is holding you back from making this giving of yourself. Is you're reluctant to give yourself? I mean, some questions of that kind ought to be put. But it reminds me of that marvelous line in Maggie Gallagher's book on the abolition of marriage, where she said, "No, it's not free love that is most venturesome. It's the vow to commit ourselves to a lifelong marriage of fidelity is the most audacious thing any one of us could do." And that's right. It's, you think, what is contained in the notion of a vow? But it's something that we recovered, and I wonder, how do we recover it just in small ways by saying, why, what is holding you back from giving yourself? It's your child. What holds you back from saying, I have an obligation to that child? Maybe things of that kind.
Well, we hope you've enjoyed listening to this episode of the Natural Law Moment. You're invited to like and share this episode on Apple podcasts as well as Spotify. from all of us at the James Wilson Institute, thank you so much for joining us, and we look forward to our next episode very soon.